Hey, Brian Parker today, got the glasses on because I'm sort of reading this and I don't like to be read to, you shouldn't either. I just want to hope that I get it on screen. A great Parker pro se case. It's a client study against AMEX. So this is a member sent in all his work that he did against American Express. American Express was suing him, I think, for 3 cards. And he fought back and used what I preach, but he did this on his own. He used some of my stuff, but this guy worked hard. And you remember, the debt collector has hundreds of cases and doesn't put any effort into their case. It's your case, it's yours. Do your hardest work. As I always say, ParkerGPT is gonna do most of the work for you, but you gotta check on it. And he did a combination of rolling up his sleeves, but also using chat box to get the best results. So I'm gonna give you his best results, something I'm happy to put on my website. That's how good it is. So attached to the video at killdebt.com will be the following templates. His answer to an American Express complaint. They did over 20 allegations against him, and that's not usual. I think they did possibly 9 counts. So there were affirmative defenses attached to the video. I'll have 2 counter-affidavits, all in Word for you to use in your case. A brief against AMEX summary judgment. They filed an AMEX summary judgment against him, and he did a masterful job. I'm still reading it. I'm going to include it, but I'm not going to discuss it because it would take forever. It's really good, but that's attached to this video. Request to produce, request for admissions, and interrogatories against AMEX, and then my show notes. So let's take a look. So what I'm going to do is show you what he says and maybe have a couple of questions or things that I say and try and move it along. I'll put the stuff on the screen so it's not necessarily boring of me just talking, but it's instructive on how you can answer creditor cases, not just AMEX. This is all you can use for your creditor cases. So let's give it a shot. Here's the case overview. AMEX sued me on 3 credit card accounts. They filed, 9 different causes of action, including breach of contract, account stated unjust enrichment. As I've stated in the past, that is what debt collectors use all the time. That is their template. Account stated, breach of contracts, and unjust enrichment, which is a throwaway. So when he says 9 counts, he's referring to the fact that he had 3 credit cards. So they just use the same 3 counts again and again on all 3 cards. So that's a debt collector 101. They always do a breach of contract, account stated if they can't prove the contract, and unjust enrichment, which is a throwaway. So what did he use? I've titled this The Smoking Gun, and here's what he says. Member, I discovered that AMEX's own SEC filings completely contradicted their lawsuit. In their Form 10-K filed with the Securities and Exchange Commission, they explicitly admit they engage in asset securitization, which they define as the transfer and sale of loans or receivables to a special purpose entity created for the securitization activity. So I attached to this video the answer, affirmative defenses, and counter-affidavit in Word, which will show all of what he's saying with the SEC filings for you to use because they're nationwide. And so he used that. And I asked him why he did that, and he said it's because they were telling the SEC, a government agency, one thing, but the lawsuit against him was quite another story. So he says their Form 10-K says these receivables are transferred and sold to American Express credit account master trust, and that these receivables are available only for payment of debt securities. But in court, they have I'm going to show you more about this. The affidavit certified that the members' accounts had not been sold or assigned by American Express. So there's a legal trickery here that he didn't go into, but if you look at your lawsuit, it'll say you're liable on an account's an account, but it's the debts that you signed up for. So they could technically say in their affidavit, ooh, we still kept the accounts if they did that, but the debt is long gone. So in his affidavit, he wrote, in his counter-affidavit, he created his own counter-affidavit. Again, it's attached along with another counter-affidavit against AMEX for you in this video. The 11 and 12, the filing explicitly states that securitized loans and receivables, he's talking about the 10K, are reported as trust assets. And number 12, when AMEX securitized debts, the cash flow, including interest and principal debt, that AMEX collects as a servicer goes to the holder and trustee of the asset-backed securities because they own the debt. AMEX's Form 10-K confirms it receives only a predetermined servicing fee. They're just services collecting on the debt for the person that owns it. which is the definition of a debt collector when the debt is in default. So they filed a motion for summary judgment against him. I'll attach their motion and his response in brief. And you can tear apart his brief to use it for your use, or if you're having a motion for summary judgment against you, filed against you, you can use the template here. So he says the affidavit is legally worthless for multiple reasons. First, paragraph 10 is the smoking gun. It swears under oath that defendant's account has not been sold or assigned, which contradicts AMEX's own governmental SEC filings. Either he's lying under oath or he lacks knowledge of AMEX's actual business practices. And that's the member referring to the affiant. Either way, the affidavit fails. So here's what other problems he found. Member says his foundational knowledge is completely inadequate. He claims to be familiar with ongoing credit card operation, but provides zero foundation. So in other words, he's trying to use the business record exception to hearsay. Everything is hearsay unless you can find an exception. The business record exception requires strict guidelines for a hearsay thing to come in. And the member clearly found that there was no foundation or personal knowledge. So here's some practical tips from our member. First, immediately search for the plaintiff's SEC filings on the SEC's EDGAR database. Look for Forms 10K and 424B5 prospectuses. Search for terms like securitization, trust transfer, and receivables. And that's what I do. And I counsel that on my videos. Just search them out and all the information you need will accompany it. In fact, one of the affidavits I'll attach to this will have the 10K filings for you attached to the affidavit. Second, when you get their witness affidavit, tear it apart line by line. I've done videos on tearing apart the affidavit. I have an affidavit checklist in ParkerGPT. Third, send validation requests under FDCPA. When they can't provide it, that's evidence of their servicer status, and they should not be claiming they own the debt or that the debt wasn't transferred. Fourth, demand trust documentation under state discovery rules. In his case, their refusal showed inferences that they were hiding the true ownership structure. So I've got this full video I'm doing right now. This is the beginning of it. Remember also when you send the FDCPA validation letters out, send out your securitization letters. In this case, the member actually sent a legal court filed document seeking the trust status as part of his case in chief. So as we go into the full video next, you'll find out the legal strategy here, and you'll see all the documents that I just mentioned that will be accompanied at killdebt.com, and we'll embed everything here, all the documents into ParkerGPT. So just with the click of a mouse, you can have all of this.